Hello everyone, hope you're all doing great today. Welcome to PW OnlyIAS English channel. And yes, we are here with the 11th chapter, Amendment to the Constitution. Without any further delay, this is my official Telegram channel, people. You can ask your queries here. You can send the PYQs of public administration and all the GS papers and essay into this channel. Please only send the PYQs in the PDF format. And the next thing is the PDF of this lecture, the PowerPoint in the PDF format also will be available in this channel. So those are all the reasons in the world for you to actually become a member of this channel. All right. Now let us head towards our topic. That is, when we talk about amendment, we must understand one thing. Our constitution can be amended. Now, is it too easy to do it or is it very difficult? It is neither too easy like in Britain, nor is it as difficult as how it is in USA. The Indian constitution therefore is called a synthesis or a blend of rigidity and flexibility. Article 368, Part 20. Parliament in exercise of its constituent power amend by way of addition, variation or repeal any provision of the constitution. That is, you can add anything, you can remove anything or make certain alterations in it. Under Article 368, cannot amend those provisions which are part of the basic structure which Supreme Court ruled in Keshavananda Bharati case 1973. It was an interesting observation also. That is basically Supreme Court told Parliament has all the powers in the world to amend the constitution, but not to tamper with the basic structure. They added a warning into it. They can amend even any fundamental rights as long as it is not part of the basic structure. Now, basic structure as a term, like I've told you earlier, is not defined anywhere in the constitution. It is actually a judicial creation, where even the judiciary has not specifically said what is the basic structure. But today we have a general idea about the basic structure through various judicial rulings, which is again our next chapter. There we will be seeing it in detail. Going further, what is the procedure for amendment? Procedure for amendment, when we talk about, you must understand one thing. The procedure to amendment can only be initiated in the House of the Parliament and not by the state legislature. State legislature can pass a resolution requesting. But other than that, if you generally see the power, the process, all of this lies only with whom? The Parliament. Can be introduced by a minister or by a private member. Basically, it means anybody can introduce it. And does not require any prior permission of the President. Must be passed in each house by a special majority. And what do you mean by special majority? Majority of the total membership of the House and the majority of 2/3 of the members of each house present and voting. So majority of the total membership of the house should be there, plus out of the total members who are present that day, in that 2/3 also should approve of it. Each house should pass the bill separately. Now, normally in the case of an ordinary bill, there is a provision for joint sitting whenever there is a deadlock between the Lok Sabha and the Rajya Sabha. Whereas in the case of constitutional amendment bill, there is no such provision. If federal provisions are to be amended, federal provisions means the state's powers are going to get affected because of that particular amendment. State's powers gets affected or the subjects in the state list may get affected. In such a scenario, ratification by half of state legislatures by simple majority is required. What is simple majority? Majority of the members present and voting is necessary. Clear, people? President must give assent. President cannot withhold his assent or cannot just, keep it pending. Once it is done, passed by both the houses, it reaches the president. President has to give the assent. This was made compulsory under 24th Constitutional Amendment Act of 1971. What are the different types of amendment? Amendment by simple majority of the Parliament. That is, for everything you don't require special majority. You can actually do it through simple majority also. Say for example, admission or establishment of new states, formation of new states, and alteration of areas, boundaries, or names of existing states. Again, what does this indicate? India is an indestructible union of destructible states. That means states, alteration of its boundary, its territory, its area, all this is a discretion of the Parliament. Parliament at will can destroy any state. Simple. That is what it means. And as you can clearly see, it only requires a simple majority. But no parliament will try to do it that, or no government will ever try to do that. Why? It will create a complete havoc in the country. Getting the picture? But otherwise, you must understand one thing here. India is an indestructible union of destructible states. This is the reason. Parliament at will can change the area, name, alteration, boundary, completely destroy a state, create a new state. All of this they can do it. Abolition or creation of legislative councils in states. For this, again, a resolution has to be passed from the side of the state. Second schedule, quorum in parliament. That is, how many members are required, minimum, to introduce a bill or to pass a bill, etc. The minimum number of members who should be present. Salaries and allowances of MPs. Rules of procedure in parliament. Privileges of the parliament, its members and its committees. Use of English language in parliament. Number of piscine judges in the Supreme Court. Conferment of more jurisdiction on the Supreme Court. Use of official language. Citizenship acquisition and its termination. Elections to parliament and state legislatures. Delimitation of constituencies. Union territories. Fifth schedule, sixth schedule. Largely you can see in most of the matters, parliament need not go for special majority. Parliament need not even take ratification by state legislatures. Second schedule, fifth schedule, sixth schedule, elections to state legislatures, etc. Now you must understand this in the context of one nation, one election. So in many matters, simple majority is only required. Alright, only in a few matters, special majority and special majority with ratification by half the state legislatures is required when it comes to the implementation of one nation, one election. Google it, find out what are those, put it up in the comment section. Clear, people? Moving on. By special majority of the parliament, majority of total membership of each house and majority of 2/3 of members of each house, which we have already seen. Total membership means total number of members comprising the house, irrespective of the fact whether there are vacancies or absentees. That is what it means. Total membership. That is, it doesn't matter if they are present that day or if it is lying vacant, elections are yet to be conducted, doesn't matter. Total membership means total number of seats in that particular house. And only in the third reading, the bill gets subjected to the special majority voting. And in that, what and all gets covered? Fundamental rights, DPSP, and whatever is not covered under the first category, that is simple majority. We saw a list of 18 items. And then the third category. What is the third category? Special majority of parliament and consent of states. That is ratification by at least half of the state legislatures. So here you have the federal structure. The special majority by ratification by half of the state legislatures is just to indicate what? That we still have a quasi-federal structure in the country. When it comes to certain matters, we have to take the consent of the state legislatures. There is no time limit for giving consent. That is the most important thing. That is, it is not necessary that state legislatures should immediately give consent. This is where it becomes important for that political party to ensure that they are not just forming government at the center, but they should have at least half of the state legislatures in the country where they are in power to make any such changes. Getting the picture here. Now, what and all comes under this? Election of president and its manner, extent of the executive power of the union and the states, Supreme Court and High Courts, distribution of legislative powers between the union and the states, Goods and Service Tax Council, 7th schedule, representation of states in the parliament, Article 368. That is the constitutional provision for amendment itself. If you want to change it, you need ratification by at least half of the state legislatures along with special majority in the parliament. Criticism of the amendment procedure. Now, amendment procedure has not been free from criticism. It has been criticized for what? There is no provision for a special body like constitutional convention or a constituent assembly. It is done by MPs only. And the criticism is what? They don't lack the expertise here. Constitutional expertise they may not have. Number one, initiating amendment lies only with the parliament, not with legislative assemblies, not with panchayati raj or municipalities. State can pass resolution for creation or abolition of state legislative councils. Like I told you earlier, if the legislative council needs to be created or abolished, state legislative assembly needs to pass a resolution for it first. Ratification by half of the states means what? Only half is required. Like I told you, if the party that is in power already has power in half of the states in the country, they can easily get what? They can easily get a bill passed. But in USA, it is 3/4. There is no time frame again given for ratification. That is, if it is required, state legislative assemblies can actually delay the ratification process and thus defeat the whole bill. Constitution is silent on whether states can withdraw their approval after according the same. That is, first time they gave the ratification. They ratified it. They said, okay, we are okay with this amendment bill. Can they later pull it off? Again, that is not mentioned in the Constitution. There is no provision of joint sitting. Process is very much similar like ordinary bill. There is nothing extraordinary about this. It is just like how you introduce an ordinary bill. Almost it is the same procedure, with the exception that there is no provision for joint sitting. Taking it further forward, that's the end. Our chapter is over. Very small chapter, people. You can quickly wind it up. Any queries or concerns are there, you can contact me here directly, as well as put it up in the comment section. All right. So calling it a day here. Wishing you all a fantastic day and happy studying. Take care.